Everyone, and thank you for coming. My name is Nicholas Olson. My main areas of practice are media and defamation law and also privacy and breach of confidence. So suppression and non-publication orders have always been a part of my practice, but I think in the last 12 months they are something that has come to broader attention because of speeches that Chief Justice Mortimer and Justice Lee gave last year on the issue of open justice. And there's also been quite a few recent federal court decisions in particular which have criticised a tendency for practitioners to misuse the suppression and non-publication order procedure by making inappropriate applications or applications that were too broad. So I thought this was a good time to take a look at the procedures in relation to suppression and non-publication orders and the proper use of those procedures. But when I sat down to write the paper, it occurred to me that there really aren't many or any good materials, reference materials to assist practitioners in this area. Ritchie's has a commentary on the Court Suppression and Non-Publication Orders Act. It, as far as I can tell, is over 10 years out of date. The most recent case that's cited in it seems to be from 2012. So what I hope to do with this paper is to provide a more up-to-date and comprehensive overview of the statutory framework and provide guidance to the authorities from the last decade about this area of law. So there is a paper which covers these areas in probably inappropriate detail. I'll be speaking to aspects of the paper, but all the detail, including the citations, can be found in the written document. We in this state are lucky that the statutory framework for suppression and non-publication orders in New South Wales and the Commonwealth shares a common DNA. There was, in 2008, a working group of the Standing Committee of Attorneys General to develop model legislation. And the New South Wales legislation, which is the Court Suppression and Non-Publication Orders Act, is based on that model legislation more or less wholesale. That applies in the Supreme Court, Land and Environment Court, Industrial Court, District Court, Local Court and Children's Court, not NCAT or the Coroner's Court. At the Commonwealth level, the model legislation was largely adopted, but there was a bit of tinkering. So authorities in New South Wales can't be applied without caution to the Commonwealth legislation. But it's largely the same, and you find that in Part 10AA of the Judiciary Act, Part 5AA of the Federal Court Act, and it's also in the Family Law Act and the Federal Circuit and Family Court Act. I'm not going to look at the situation in the other states and territories. Frankly, it's a bit of a mess. The Victorians have the Open Courts Act 2013, which has some commonality with our legislation, but it is quite different. And in the other states and territories, it's a mess of common law and subject-specific legislation. But luckily for us, we're in a situation where we as practitioners have one legislative scheme which is largely common between the Commonwealth and New South Wales. The starting point for thinking about these orders is the public interest in open justice. That is a mandatory consideration under Section 6 of the Court Suppression and Non-Publication Orders Act and Section 37AE of the Federal Court Act. And I'll come back to what the legislation says in a minute, but open justice is one of those fundamental common law concepts that we all think we know what it means. And we all use it in a way where we tend to speak about it as though it was an absolute. Freedom of speech is a similar kind of subject. What needs to be borne in mind when we're thinking about these kinds of orders is that open justice is a practice that common law courts have adopted for a particular reason. And the reason is because common law courts have taken the view that exposing their proceedings to public scrutiny is the best way to ensure the integrity of the courts and to ensure public confidence. And that's unquestionable, but that is the purpose for which this practice exists. The courts have said that open justice is not a value which exists for its own sake. It exists to further that purpose. And so when we're dealing with suppression and non-publication orders, one thing that needs to be borne in mind is the extent to which the public interest in open justice would be adversely implicated by the making of orders under these acts. And not all orders will have the same implications for the openness of the proceedings. I give a fairly trite example in the paper, which is closing the court or suppressing the reasons for judgment are very serious intrusions on open justice. But redacting phone numbers and email addresses from exhibits is trivial and has no meaningful bearing on whether or not the public is adequately informed of the reasons why courts come to the conclusions they do. This kind of, I shouldn't call it a balancing exercise, but these considerations are reflected in Section 6 of the Court Suppression and Non-Publication Orders Act and also Section 37A of the Federal Court Act. Because what the legislation says is that in deciding whether to make one of these orders, a court must take into account that a primary objective of the administration of justice is to safeguard the public interest in open justice. So it uses the indefinite article. The legislation doesn't say that open justice is the primary objective. It doesn't say that it's the paramount objective or that it's more important than anything else. It says that it is one of the primary objectives, and that means that there are other primary objectives too. For example, the fair trial of people accused of crimes. Open justice is a fundamental starting point for the analysis of whether a suppression or non-publication order should be made, but it doesn't control the construction of the rest of the legislation. It's something that the courts will give significant weight to and must give significant weight to, however, and it is a mandatory consideration. The types of orders that the court can make are set out in Section 7 of the Court Suppression and Non-Publication Orders Act and Section 37AF of the Federal Court Act. And I've set out those provisions in full at paragraph 16 and 17 of the paper. In both jurisdictions, there are two types of orders that can be made. One is a suppression order, the other is a non-publication order. I think practitioners sometimes use those terms interchangeably. They are actually different things. A suppression order is defined in the legislation as an order which prohibits or restricts the disclosure of information, whether by publication or otherwise, but a non-publication order only prohibits or restricts publication. So what does publication mean? That's a defined term too, and it means the dissemination or access to the public or a section of the public. So in defamation law, for example, to publish something means to communicate it to a third party. You can publish something by communicating it just to a single person. That's not the way the suppression and non-publication legislation defines the term. It's got to be to the public or a section of the public. I give in paragraph 23 of the paper an example of how that could work in practice. There was a case called Commissioner of the AFP in Kogan, and a non-publication order was sought in that case. And the Commissioner of the AFP sought a carve-out, and he sought the carve-out on the basis that the Proceeds of Crime Act permits him to disclose information to authorities such as Commonwealth or State Police or the Tax Office. Justice Garling held that the carve-out wasn't necessary in that case because publication to a person like the tax office or a state police force wouldn't be publication to a section of the public. That's a defined category of person which is less than a section of the public. So the breadth of a suppression order is that it prohibits or restricts any disclosure of information, whether or not it's to a section of the public. Disclosure of the information to only a single person could contravene a suppression order. Now, these orders can prohibit or restrict. What that means is that the court can, and indeed the court must, tailor the order to ensure that it does the minimum necessary to achieve its purpose. So the order shouldn't be any more extensive than is necessary to satisfy one of the purposes which is authorised by the legislation. And if the court can do less than prohibit entirely, if it can merely restrict aspects of publication or disclosure, that's what the court should do. The New South Wales legislation permits the court to prohibit or restrict the disclosure of two kinds of information. One is information tending to reveal the identity of or otherwise concerning any party or witness, or any person who is associated with a party or witness. It's important here to realise that party in the legislation is defined not just as the parties on the pleading, but also any person who is named in the evidence. That's extremely broad. It also includes parties to proceedings which have concluded. An order to prohibit or restrict the disclosure of information in relation to a party or witness's identity extends to pseudonym orders. So that's the first category of evidence. The first category of order. The second is an order that prohibits or restricts the disclosure of information that comprises evidence or information about evidence given in the proceedings. So those two categories are also available under the federal court legislation, but the federal court legislation is broader because you can also get an order to prohibit or restrict the disclosure of information obtained through discovery under subpoena or that's been lodged or filed with the court. Now, the grounds on which suppression and non-publication orders can be made. These are defined in the legislation, and when an application is made, the application has to be brought within one of the grounds permitted by the legislation. In New South Wales, that's Section 8 of the Court Suppression and Non-Publication Orders Act, which I've set out in full at paragraph 26 of the paper. And in the Federal Court, it's Section 37AG of the Federal Court Act, which is at paragraph 27. The grounds of these, and I'll consider each of them in more detail. A, that the order is necessary to prevent prejudice to the proper administration of justice. B, that the order is necessary to prevent prejudice to the interests of the Commonwealth or a state or territory in relation to national or international security. C, that the order is necessary to protect the safety of any person. D, that the order is necessary to avoid causing undue distress or embarrassment to a party or witness in criminal proceedings involving an offence of a sexual nature. And in New South Wales, there's a fifth one, which is that the order is otherwise necessary in the public interest, and that public interest significantly outweighs the public interest in open justice. Each of those grounds is subject to a test of necessity. And this is the crux of the jurisdiction to make suppression or non-publication orders. In order to have a proper basis to make them, the court needs to be satisfied that the order is necessary for one of those purposes. And all of the authorities emphasise that necessary is a very strong word. It imposes a heavy onus on the applicant, and it goes without saying that the applicant has an onus of proof. And the use of this term necessary reflects the fact that orders shouldn't be made except in exceptional circumstances. They're not run-of-the-mill orders. On the other hand, courts have also emphasised that a narrow view shouldn't be taken of what may be necessary in particular circumstances. It's an evaluative exercise and it involves questions of degree. Justice Nettle gives a good example when he was sitting as a single judge in a High Court case called A, B and CD. And the example he gives is seatbelts. Every sensible person regards wearing seatbelts as necessary to protect safety when you're on the road. That doesn't mean that if you don't wear a seatbelt, you're going to crash the car. You're definitely going to crash the car. You probably won't. You'll probably reach your destination just fine. But seatbelts are necessary because the consequences of not wearing one when you do crash the car is you die or get seriously maimed. That is, the consequences of something going wrong are so bad that this relatively uninvasive precaution is necessary in the interests of your safety. And that's the kind of evaluative exercise that, as we'll see later on, is involved in considering the necessity of suppression or non-publication orders, particularly when they're sought on the basis of safety. However, it needs to be emphasised that a suppression order or a non-publication order is either necessary or it's not. There's no balancing exercise involved in this. Courts can't make them just because it would be convenient to do so, or it be reasonable or sensible, or it doesn't prejudice anybody else. But once the court is satisfied that the order is necessary, the court has no discretion not to make it. It's an error not to make the order at that point. So what we need is a cogent and non-speculative basis which is supported by adequate evidence in order to satisfy a court that one of these orders is necessary. You don't get them just because you ask for them. An order also won't be regarded as necessary if it would be futile, meaning that it wouldn't be effective to achieve one of the purposes that's authorised by the legislation. And this is typically the case when there's already been a degree of publicity and the information that you're trying to make the subject of one of these orders has entered the public domain to some extent. This again is a question of degree. Even if the order has entered the public domain to some extent, there may still be a jurisdiction to make the order to prevent further disclosure if it hasn't become a matter of common knowledge. But these will be matters for evidence in the particular case. So I want to turn now to evaluate each of those grounds for making a suppression or non-publication order. Starting with prejudice to the proper administration of justice. And the question of what the administration of justice requires is a huge topic. It's best illustrated by examples, which is what I'll do in a moment. But a couple of introductory observations. First, open justice is in itself integral to the proper administration of justice. There's no tension between the two topics, the two values. So to say that a suppression or non-publication order is necessary to prevent prejudice to the proper administration of justice means that the countervailing interest is so powerful that it overrides the fact that the proper administration of justice normally requires open justice. Secondly, and relatedly, the administration of justice isn't prejudiced by minor or trivial departures from ordinary court procedures. And we should remember that departing from open justice is itself quite a significant departure from ordinary court procedures. And the third thing to consider is that the administration of justice is not just about the particular case before the court, but what might happen in future cases. And particularly when we consider topics such as confidential information, this is a consideration that comes to the forefront. So perhaps the biggest area where the proper administration of justice is implicated is when it comes to ensuring that accuseds in criminal matters have the opportunity of a fair trial when they're to be tried by jury. And there's lots of ways in which pre-trial publicity or other forms of extraneous information can prejudice the trial of an accused person. But courts don't take the view that jurors are fragile or prone to prejudice. So courts are not going to be satisfied that just because prejudicial material is out there somewhere, there is a real possibility that the trial is going to be prejudiced. You need to show a bit more than that. And the key question is really whether the likelihood that the jury will be prejudicially affected by a particular piece of information and the extent of that prejudice is such that the order is necessary. And there's a couple of things to consider when evaluating that. The first is you've got to show that there's a real and substantial basis for thinking that there's something within the relevant material that actually will prejudice the mind of the jury. And that's going to depend on the content. It also might depend on the medium. So one famous example from Victoria is the Underbelly TV series. You perked up when that was mentioned. So there's a case called General Television Corporation and the DPP in the Victorian Court of Appeal, which had to do with the suppression of the first Underbelly series, which was due to be broadcast while the trials of some of the defendants in the Melbourne gang wars were actually ongoing. And this was a fictionalised portrayal of the Melbourne gang wars, but it dramatised what the jury was going to be hearing about in court. And because it was attended by this colour and movement and excitement, it was quite a sexy, dramatic sort of TV series, there was a particular risk that jurors would not distinguish fact from fiction when it came to that kind of material, because it was the kind of thing which was so likely to influence a person's mind. On the other hand, there's a full federal court case called County Care Group and the DPP in 2020, where it was suggested that reasons for judgment in a prior case needed to be the subject of a non-publication order lest they prejudice a subsequent jury. And the court went through the reasons for judgment that had been delivered and said, realistically, there's nothing in this, assuming a juror even sees it, there's nothing in this which is going to prejudicially affect the way they approach a subsequent criminal proceeding. So that's the first consideration. The second is the time lag between the publication of the prejudicial material and the accused's trial. The longer the delay, the lower the risk that the prejudicial material will actually affect the trial. It's not useful to try to categorise periods which are long enough or not long enough. In the Lerriman case, before the Lisa Wilkinson-Logies issue, there was a previous application to stay the proceedings on the basis of prejudicial pre-trial publicity. And Chief Justice McCallum was not satisfied that it would affect the trial because the trial was about 2.5 months away at that point. I think that's the shortest period I've seen, but equally you could well imagine a situation where there was something extremely prejudicial and extremely widely publicised that occurred further out from the trial. And it's really not possible to be doctrinaire and say that a certain period is long enough or not long enough. What we can say is that if the accused hasn't even been charged yet, a court is very unlikely to entertain an application on this basis. I did a matter recently called Smolin and the Daily Mail, where Mr. Smolin sued for defamation in relation to an article about his treatment of women on dating apps. And in the course of the proceedings, a document was produced on subpoena which was Mr. Smolan's theories on dating and women. And the view that I took and my solicitors took was that this book contained admissions as to serious criminal offences. And so we sought and obtained a release from the Harmon obligation to refer that book to the police. Mr. Smolan sought a non-publication order over the book, and one of the bases on which he sought it was if he was charged, his trial might be prejudiced by the reporting that the Daily Mail proceeded to do in relation to the book. That was rejected. He was not even being investigated by police. He hadn't even been charged. There was no real likelihood that in those circumstances there would be any prejudice. On the other hand, if the prejudicial publicity occurs during the trial, like in the Underbelly case, the risk is very serious indeed. And in those circumstances, an order is highly likely to be made. The third thing that courts take into account is the fact that jurors are given directions as part of the criminal trial process. It is a criminal offence for jurors to research extraneous material. That's an offence under Section 68C of the Jury Act. And jurors are routinely given directions by trial judges about the necessity to not do this. And it is a deeply rooted assumption of the common law that jurors do what they're told. That may or may not be true, but it's an article of faith. So in paragraph 47 of the paper, I quote Justice McHugh as saying in one case, to put it bluntly, unless we act on the assumption that criminal juries act on the evidence and in accordance with the directions, there's no point in having criminal jury trials. So the question for a court considering a suppression or non-publication order application is, what is the likelihood that jurors will act in deliberate defiance of the direction that they will no doubt be given by the trial judge? And that tends to be a risk that the court assesses low. Courts are inclined, and I've given lots of authorities in the paper, to give effect to the assumption that jurors will do what they're told and will follow directions. That's not to say that these orders won't be made in appropriate cases. Courts do recognise that although juries generally have integrity, it's not a good idea to put that integrity to the test in every case. But it's evaluated from the perspective that jurors are generally regarded as doing what they're told and they're not considered to be particularly prone to prejudice. So that's the first category. The second is trade secrets and confidential information. There seems to be an assumption out there that you get suppression or non-publication orders just because information is confidential. That's not the case. The mere fact that something is confidential doesn't in and of itself establish that one of these orders is necessary to prevent prejudice to the administration of justice. When the confidential information is itself the subject matter of the dispute, like a breach of confidence case, the orders might relatively readily be given because the court recognises that it's pretty absurd to put a party in the position of having to divulge its confidential information to the world in order to enforce that right. That would deter people from coming to court to enforce their rights, and that is a prejudice to the administration of justice. When the confidential information isn't the subject matter of the dispute, the court might still protect it if there's evidence that the value of that information would be seriously diminished by disclosure. And the principle that the court acts on in these cases is that it's not good for the integrity of the court for it to become a vehicle for commercial competitors to gain advantage over each other or to potentially profit from the processes of the court to find information about their competitors that they can exploit. That is open to abuse. But courts won't just accept a party's assertion that information is confidential. The court will actually test that. So in paragraph 54 of the paper, I give the example of a case called Right Prospecting and Hammersley Iron, where Justice Hammerschlag, to his bemusement, was told that a joint venture agreement was confidential and went through it line by line and pointed out that it was really all boilerplate and said nothing of any substance. And so he refused to accept that it was confidential and rejected the application. A third category under the head of prejudice to the administration of justice is the need to ensure that parties or complainants or witnesses aren't discouraged from engaging with the legal system. So there are some kinds of cases where if a person was not assured of confidentiality, they might prefer not to come to court at all. And the classic example of that is blackmail and extortion cases. If you are the victim of blackmail or extortion, you're worried about the material that you're threatened with being made public. And if the consequence of going to the police or going to court to seek an injunction was that it was going to become public anyway, you wouldn't engage with that process. And that's prejudice to the administration of justice. So that's the first ground for getting suppression or non-publication orders. The second is national and international security. I don't propose to say very much about that. It's fairly obvious. It is one where you tend to see courts showing greater deference to the applicant, especially if it's the Commonwealth or a state. And if there's evidence from a police officer or a military officer or an intelligence officer that a particular disclosure would prejudice security, the court's not going to second guess it. And that's the reality of the situation. The third category is safety. And this is the safety of any person, whether or not they are a party to the proceedings. The approach that the court takes in these situations is a calculus of risk. It's known as in the authorities. And that means that the court doesn't have to be satisfied that it is more probable than not that the person will suffer harm if the order isn't made. The court looks at the probability of the risk, but also how serious it would be and the nature of the steps that are needed to be taken to mitigate the risk. So I go back to the seatbelt example. If you have a risk which is perhaps less probable, but very serious if it happens, it's more likely to be necessary to make an order than a risk which might be high probability but low seriousness. Safety also includes not just physical safety, but psychological safety. We're not talking about hurt feelings, but at least in the realm of diagnosable mental illness, that is something that's capable of being protected under this ground. And also risks of self-harm and suicide, but that's going to need to be supported by expert evidence. The next category is undue distress or embarrassment to parties or witnesses in criminal cases involving sexual offences. I'm not going to address that in detail. I think it's perhaps curious that it's limited to criminal cases and not, for example, defamation matters like Lerriman, which involved allegations of sexual misconduct. The witness is in the same position. Or why it should be limited to sexual matters and not other cases where a person might suffer serious distress. And I give the example in the paper of the family of a murder victim who sees footage on TV of their relatives' remains being loaded into an ambulance. That may be extremely distressing for them, but for some reason it's not covered. And I would note that the Victorian legislation is broader and it extends to family violence offences and not just sexual matters. In New South Wales, as I said, we have this fifth additional category which is otherwise necessary in the public interest. I've given some examples in paragraph 69 of the paper of where orders of that kind have been made. I think what's interesting about the use of that provision is that we tend to see it being used to plug some of the gaps in the other four categories. So For example, you can get a suppression or non-publication order to prevent information about intelligence or military capabilities or technologies or tactics being disclosed on the basis of national security. But in a case called the Crown against Musler, number 2, Justice Adamson made an order under the otherwise necessary category to prevent the disclosure of sensitive police capabilities, where it would prejudice law enforcement operations if that was disclosed. So that was short of national security, but by analogy, the necessity was demonstrated. There are some other very interesting examples, like the matter of Lacey and the Attorney General, which was a case where a teenage Aboriginal woman was strip searched, and that was filmed. And orders were sought to prevent men from viewing that footage. And in the Court of Appeal, it was suggested that orders could be made under the otherwise necessary head of the Court Suppression and Non-Publication Orders Act. And it was otherwise necessary to respect Aboriginal cultural norms concerning women's business, because there was evidence before the court that it would be extremely culturally sensitive for footage of this woman undergoing a strip search to be seen by men. So that was a very interesting application of it. So those are the grounds. I'll just turn briefly now to address some aspects of procedure. Section 9 of the Court Suppression and Non-Publication Orders Act and Section 37AH of the Federal Court Act sets out who's entitled to make an application and who's entitled to be heard on it. The application can be made by a party, and as we've seen, that's a very broad term that includes people named in the evidence, or any other person that's considered by the court to have a sufficient interest. There was recently an example of an application being made by somebody who wasn't a party in the traditional sense, in Latouth and the ABC. So in that case, there was an application by some people who had made complaints against Antoinette Latouth. And they were worried about the prospect of vilification and harassment if their identities as the complainants was publicised, and there was evidence to support that. And orders were made to protect them under the safety ground. So they were considered to have a sufficient interest. Another important thing to note about who is entitled to be heard is that the media have a right to appear on applications for suppression and non-publication orders. The media is differently defined in the New South Wales and the federal legislation. The statutory phrase in New South Wales is news media organisation, and that is defined as a commercial enterprise that engages in the business of broadcasting or publishing news. That on its face is biased in favour of traditional corporate media. The federal phrase is news publisher, and that's defined in the Federal Court Act as a person engaged in the business of publishing news. So, at least in principle, the federal definition is capable of being broader and embracing perhaps a blogger. There are limits. So Shane Dowling had a go in Porter and the ABC, but he was knocked back because the court did not think that his contribution would be of assistance. But he did claim to be a news publisher under the definition. The role of the media as an intervener is important in these cases because often the parties, the actual parties to the dispute, have no real interest in opposing one of these orders. And the media is often the real contradictor in these cases. That's particularly the case when orders are sought by consent. Because the test is one of necessity, the fact that the parties consent is not determinative, and the court actually has to be satisfied that the order is necessary, whatever the parties say. And there have been cases where courts have rejected proposed consent orders because they weren't satisfied of the necessity. We as practitioners have a duty to try to assist the court, but that doesn't always happen. And that's the importance of the statutory right for interveners like media organisations in these cases. One other important procedural aspect is that orders need to specify the duration and the geographical limit of the order. So you have to specify either a fixed period or an end date. So a fixed period could be 20 years, for example, or an end date or an ending event could be until the discharge of the jury in the trial of so-and-so. It's not good practice to express the orders as operating until further order. That's quite vague. It does happen a lot, but it shouldn't be done, and it's been criticised by Justice Baston, among other people. In terms of geographical distribution, a review of the New South Wales authorities does suggest that it is overwhelmingly common to make the orders apply throughout the Commonwealth. That has been criticised by Justice Baston in the matter of Fairfax and Ibrahim, where he pointed out that if, for example, somebody was being tried in the District Court at Sydney, it was very difficult to see why publication in Darwin or Kununurra should be suppressed or subject of a non-publication order. I think that kind of criticism, although attractive at an abstract level, doesn't grapple with the reality of internet publication. And the reality of internet publication is if you don't make the order apply throughout the Commonwealth, it's likely not to be effective. Interim orders. Section 10 of the New South Wales legislation and Section 37AI permits the court to make an interim order without determining the merits of the application, but the court has to resolve the application as a matter of urgency. This is useful when, for example, you seek urgent orders ex parte from a duty judge. The interim order procedure also allows orders to be made on a holding basis until interveners like news organisations can appear at a later date. The interim order procedure doesn't require the court to be satisfied that the order has merit, but the merits aren't irrelevant. The court doesn't just hand them out because you ask for them. You do need to at least demonstrate a prima facie basis for the court to see that you might get a suppression or non-publication order on the merits. And they do have to be determined as a matter of urgency, so interim orders can only be in place for a matter of days at most. Just briefly to conclude on the review and appeal procedures. In New South Wales, Section 13 of the Act permits the court that made the orders to review them at any time. You can also appeal under Section 14. Review or appeal are alternative options. You can also appeal a decision to review or not review the orders. And the appeal is said to be by way of rehearing, but Section 14 of the Act permits fresh evidence to be adduced. So the courts have said it's really more akin to a hearing de novo. There's no specific provisions on this in the Federal Court Act. What the Federal Court has said is that suppression and non-publication orders are interlocutory. That means that they can be varied under the Federal Court rules. The rule is FCR 39.05C. And the applicable appeal mechanism in the Federal Court is Section 24(1)D of the Federal Court Act. So leave is required to appeal. And it's an appeal by way of rehearing, but without the facility to adduce fresh evidence. So look, that is the overview. As I said, there's a lot more detail in the paper, and I'm happy to take questions if anybody has questions. No? Oh, yeah.
I was wondering if you had your application rejected and then you didn't appeal, do you think it would be possible to bring a fresh application with new evidence later on?
Well, it's possible jurisdictionally in the sense that there's power to do that. But if the application is rejected and the information is disclosed, you'll run into a futility argument if the order's made at a later date once the information is entered the public domain. And as I said before, that's a question of degree. So if the if the information hasn't entered the public domain to a large extent, you may still be able to salvage the situation. But that is the argument you'd be met with. Yep, Duncan?
Do you have a view on whether a requirement should be introduced whereby the media are notified of an application suppression?
I don't see why it shouldn't be left in the discretion of the judge hearing the application. The legislation does clearly state that the media have an entitlement to be heard. There's also, as I understand it, at least in some jurisdictions, a procedure for notifying the media once the orders have been made. And even if a procedure like the one you suggested was mandated, what would at least happen is that an interim order was made pending the appearance of the media organisation to oppose it. So I don't know that it would make much difference because the order gets made, media organisations get notified of it, and then they can decide whether or not they wish to appear. I mean, my view is prescriptiveness should be avoided, and it's better that these kind of things are left at the discretion of the judge. Yeah.
I've simply seen orders made where the material protected by the order seems to already be covered by self-executing statutory provisions.
Yeah.
Can you say a little about the interaction between the necessity test and those statutory restrictions or prohibitions that may also exist?
Yeah, so that's a good point. There are lots of subject-specific statutory prohibitions, for example, in cases involving sexual offences. I can give you one example, actually, which is in the paper. If you turn to paragraph 69, E, there have been a couple of cases in the New South Wales Court of Appeal where orders have been made under the otherwise necessary ground to prohibit disclosure of the identity of people who are parties before the Mental Health Review Tribunal. So there is a provision in the mental health legislation which suppresses the identities of people who are parties before the tribunal. What then happens is there is, for example, a judicial review application from a tribunal decision to the Supreme Court. And I'm not familiar with the mental health legislation, but I understand that what happens in those cases is the protection is lost once they enter the Supreme Court ecosystem. And so orders can be made under the otherwise necessary provisions in those circumstances to close the gap. As a general proposition, I would say that if there is another piece of legislation out there which mandates a form of suppression or non-publication, a court is likely to be more comfortably satisfied that it's necessary under one of the other grounds, as long as you can bring it under one of the other grounds. Because the fact that Parliament has said that in a particular, well, it can really cut both ways, because if Parliament has said in a different statute that information should be subject of suppression or non-publication, the court might take the view that the limited extent of the other legislation is indicative of Parliament's intent that it shouldn't be further suppressed. So it's going to depend on the individual circumstances. But the court would definitely give close consideration to any other subject-specific legislation which touches on the issue. Yeah.
We have an online question. What do you make of Mortimer CJ's comments about open justice needing a modern rethink?
Yeah, so what the Chief Justice suggested in that paper was that it might be more apt to speak of accessible justice rather than open justice. And I think that when you read Her Honour's, the speech that Her Honour gave in full, what she is saying, I don't think should be especially controversial, which is similar to what I said earlier, that as important as the practice of open justice in the common law tradition is, it is a practice that's developed for a particular purpose. And there are examples of infringements on open justice which really don't undermine the fundamental purpose of that practice. The point is that the public should be able to understand what courts do and why they do it. And my view is that the Chief Justice is right with respect when she says that doesn't mean that we need open slather on everything and anything to do with court proceedings. The lodestar ought to be whether the public has sufficient information to understand the business of the court. Any other questions? All right. Well, thank you all for coming.